Fletcher Tabata.
Thank you, sir. I would add my voice to those who have noted the sponsoring member's aptitude, his intelligence and his considered debate in the House oft times. And in fact, I'd like to acknowledge Melissa Lee as well. She gave a good contribution this evening, so much so that both of them combined together actually made me think about my position. But in the end, it is a commiseration speech I give to Mr Reti because this is a non-event. It is a problem an answer to a problem that doesn't really exist. And the cyclical nature of the contributions from that side of the House kind of underlie the issue with this piece of legislation. And then Mr Hudson gave his contribution, which didn't help the government's cause whatsoever. What I would point out to Mr Hudson, Mr Speaker, is he failed to recognise the Responsible Lending Code, which he kind of alluded to, but let's talk about that in a little bit more detail for the members and the public's consideration. It provides the general principle that every lender must exercise the care, diligence and skill of a responsible lender when advertising, before agreeing to provide credit or finance or taking guarantees, and sir, in all subsequent dealings with borrowers and guarantors. The Code lays out the responsibilities lenders owe to consumers in considerable detail. So I put it to Mr Reti that he's kind of missed an opportunity here, and in fact he's using the wrong piece of legislation to deal with this problem that doesn't really exist. He mentioned stakeholders in his original contribution, and I put it to the members on that side of the House that I think he was talking to the wrong stakeholders, sir. He wasn't thinking about the consumers when he was engaging with those stakeholders. And for example, I agree with Mr Sheeran, his contribution. This is more about limiting the protection of consumers than it is about improving them. It is about increasing or improving the protections of the lenders. And New Zealand First would suggest to this House, sir, that that is not the recourse or the protection that we would want for New Zealand consumers. So, regardless of how well-intentioned the member's bill may be, the effect would be, sir, to weaken the protection of consumers under the Act. On principle, New Zealand First believes that where consumers, suppliers and lenders' rights intersect, there has to be a presumption and a preference to protect the consumer in those incidents, especially when we're talking about the Consumer Guarantees Act, sir. I've listened to the member and why he believes the bill would be good. However, we do not believe that insofar as an issue of unrelated lenders being liable under the Consumer Guarantees Act exists, that this bill is the best way to address the issue, as I intimated earlier, sir. Instead, if an issue does exist, we would argue that these definitional issues are best resolved by the discretion of the courts, and they have thus far been doing that, sir. This is a 1993 piece of legislation, and the courts have been using that piece of legislation to process these problems. Our courts have the ability to interpret this Act. The courts have this kind of broad interpretative discretion, and I believe that they are better placed to deal with the issue that Mr Reti so eloquently speaks to. So, look, it's pretty clear. I think the intention may be right, but I think it's a missed opportunity. We wouldn't support this going further. It's an answer that doesn't actually have a problem, and we would like it not to proceed and cannot support it. Thank you, Mr Speaker.